Thank you, everyone. Please be seated. Our cameras don't show it, but we have a courtroom. It's my understanding the students who are here represent Woodward Granger. Is that correct? I see a lot of heads shaking yes. Okay, thank you. Welcome. This is a public oral argument. We appreciate the opportunity for you to watch what we do. I'm going to really quick just go down the line in order of seniority on the bench and tell you what high school we graduated from. I graduated from Harlan in Iowa.
Dubuque Senior High.
Bettendorf.
Lexington High School in Massachusetts.
Des Moines, Lincoln.
Greenfield High School, which is now Nottoway Valley.
Kemper Catholic in Carroll.
Okay, thank you. Our final argument for the morning is State of Iowa versus Davison. And I didn't ask, it looks like we have Lucee Laursen, who's a law student and going to argue. Which high school did you go to? I'll let you announce it when you get up there. Same with Martha Trout when it's your turn too.
I went to Unalaska High School in Wisconsin, so not quite an Iowan, but close.
Approach and begin when you're ready.
Okay. May it please the court, counsel. My name is Lucee Laursen. As stated, I am an intern at the Appellate Defender's Office, and today I am here representing Mr. Davison. This court has previously found that 910(3)(b) is punitive in nature. Therefore, the sentencing court violated Mr. Davidson's due process right and right to a jury trial when imposing 910(3)(b) without a jury finding beyond a reasonable doubt that Mr. Davidson's felonious acts caused the death of Mr. Chu. It is well established in Isolina and Corwin that Section 910(3)(b) is in fact a fine. Further, in Corwin, the court held that 910(3)(b) is a sentencing enhancement. Therefore, the Sixth Amendment is triggered. The Sixth Amendment requires any factual determination that increases a defendant's sentence must be proven beyond a reasonable doubt by a jury or a fact finder. In other words, in this case, in order for 910(3)(b) to attach, the jury must have found beyond a reasonable doubt that Mr. Davidson's actions were the cause of Mr. Chu's death.
So in this case, he was convicted of assault causing serious injury. What was the serious injury that he caused?
So Mr. Chu was shot a total of 7 times, and so it's not necessarily clear based on the jury's conviction of that particular charge which shot. Like I said, there were 7. There were several shots that the medical examiner determined would not have killed Mr. Chu or resulted in his death. And so therefore, based on the jury's finding and conviction, it is likely that the jury would have found that one of those 3 non-fatal shots were the shots that Mr. Davidson was one of the shots that Mr. Davidson had potentially shot the victim. So because again, Mr. Davidson was actually acquitted of several other higher counts, and those would have had an element in which the action that Mr. Davidson took actually did cause the death of Mr. Chu, but...
The fact's correct. So there were 2 shooters?
Yes, correct.
Them? Is there an acknowledgement on his behalf that he was one of the 2 shooters and there were 7 bullets and the guy died?
I am not 100% sure that there's an acknowledgement by Mr. Davidson that he was one of the 2 shooters. However, there were 7 shots, of which I believe 3 or 4 of them were non-fatal. And so, as I said, it's very possible that the jury, in acquitting him of several higher counts, had determined that Mr. Davidson was not beyond a reasonable doubt, his actions did not beyond a reasonable doubt cause the death of Mr. Chu.
And limited to just the $150,000 statute? You're not saying there's a right to a jury trial on other forms of restitution, are you?
So based on this court's precedent in determining that 910(3)(b) is actually a fine, that's where we get into the due process and Mr. Davidson's right to a jury trial. whereas other forms of restitution would not trigger due process, and it would not trigger Apprendi, as the state had cited many different cases in which the codes were considered to be restitution, and therefore.
How about the obligation to pay attorney's fees or jail fees or court costs? Is there a right to a jury trial on those?
So no, we're not saying that there's a right to a jury trial on those. However, I believe that there would still be like a right to a hearing to determine the damage amount, that sort of thing, that already exists. A right to a hearing in the sentencing judge to determine.
Compensatory, are they?
So no, like the rest of restitution, I suppose, would not necessarily be compensatory. However, there are other things like other pecuniary damages that perhaps you could consider to be. So 910(3)B is different than a lot of other portions of restitution.
150,000 intended to be compensation for the victim's family.
Disagree. I think it's more so the legislative aim of 910(3)B was more so to deter people from committing acts that would result in the death of another individual. You still have pecuniary damages that would be calculated and paid out to the family, as well as victim funds, that sort of thing.
Go to the victim's family? I mean, isn't this really like a wrongful death statute, where it's sort of the automatic, payment to the family?
It does go to the victim's family as opposed to going to the state. However, in Isolina, the court had determined that that doesn't necessarily have a bearing on whether or not this is considered a fine. The reason being that in Isolina, the court is determining whether or not the $150,000 is an excessive fine amount. And in so doing, they determined that the excessive fine clause is to limit the state's ability to essentially punish the defendant. And it's irrelevant, according to Isolina, that the $150,000 is going to the family versus going to the state. Similarly here, the right to a jury trial is again to ensure that if we're going to take someone's liberty rights away or pursuit of happiness rights away, that sort of thing, essentially that you have a right to a jury, and that the government needs to have essentially its eggs in a row beyond a reasonable doubt in order to punish someone further through a fine.
Isolina, it's sort of hybrid, right? We said it's partly a fine and partly compensation, right?
Now, I think the court found that there are multiple different purposes in 910(3)B, and because, though, the purposes do include deterrence and rehabilitation, for example, that sort of thing, it's considered to be a fine. And so I think that, 910(3)B can serve multiple purposes. However, then we do need to make a choice of whether or not we're going to consider it to be restitution or a fine, because that would change the analysis of basically the causal element here in the code.
Text, some of the courts that have rejected the application of Apprendi to restitution have relied on sort of the hybrid nature of restitution. Why shouldn't we do that?
Based on this court's precedent in Isolina and followed by Corbin and several other cases has been followed, this court has determined itself that for federal purposes, 910(3)B is considered to be a fine. And so I think then if we were going to today decide that either this is some sort of hybrid or perhaps more something along the lines of restitution, you would need to overturn some of the precedent that exists classifying 910(3)B as a fine.
That it could be a fine for some constitutional purposes, but not others. So in Isolina, we said the award is a fine, quote, within the 8th Amendment of the U.S. Constitution, Article 1, Section 17, but maybe it wouldn't be a fine for other purposes. Is that possible?
It's possible. However, as I was kind of speaking to earlier, the purpose behind the excessive fine clause is to limit the government's power in punishing a criminal defendant. Similarly, the right to a jury trial and to have a fact finder find beyond a reasonable doubt that you are in fact guilty of whatever it is, that's a similar motivation.
Though with forfeiture, cases, where those are subject to constitutional regulation, but not necessarily right to trial by jury.
I guess that might be the case. I don't have,
I think, and correct me if I'm wrong, but my recollection is in Timms, the court held that those could be subject to Eighth Amendment excessive fine jurisprudence, but not necessarily that the defendant would have a right to a jury trial on the forfeiture issue. Couldn't this be a similar situation?
I'm not familiar with the Timms case that you're referring to, but I suppose that it could be, again, the case that in some constitutional perspectives or scopes, that this were to be considered restitution, in others it could be considered a fine. However, I do think, again, in Corwin, the ex post facto case that upheld that this is a fine, again, because the legislature's aim was punitive in nature, this is considered to be a fine. And I do think the fact that Corwin further adopts that this is a fine is, again, exemplary of the fact that 910(3)B is a fine. If we look at other statutory fines in Iowa's code, for example, certain fines attached to different levels of felonies, there is a minimum amount that is statutorily given. Similarly, in 910(3)B, there's a minimum amount, and the maximum amount, though not explicit, is, according to Isolina, the excessive fine clause, so there still is a maximum amount to this fine, whereas the rest of restitution is calculated like civil damages. And so I do think it's very different than the rest of restitution and the rest of the restitution code, and therefore should be treated.
Different? I mean, you get an offset for civil judgments or civil settlements, and I think most people would say that $150,000 is a pretty low award for pain and suffering and all the intangible damages that you couldn't get under the rest of restitution anyway for the death of a person. And in this case, there was one joint and several award, as I understand it. So all the convicted defendants were ordered to pay $150,000, but anything that one defendant paid would be offset against what the other defendants owe. Isn't that right?
It actually is a bit confusing. Some of the court's documents say that all, I believe there are 4, are joint and severally liable, and others do not mention my client, Mr. Davison. I'm not sure if that was just a clerical error, if that was intentional. However,
Verbal sentencing, it was mentioned that it would be joint and several.
this case, I'm referencing there are a few other cases that are attached, and some of them included Mr. Davison, some of them did, and I assume it's a clerical error.
Why wouldn't this be harmless error on this record?
The imposition of 910(3)B? Well, I think because the jury was presented with several different charges in which they could have found that Mr. Davidson's acts were beyond a reasonable doubt the cause of Mr. Chu's death, and they acquitted him on those charges. And so the state has already had their opportunity to prove beyond a reasonable doubt that Mr. Davidson's actions caused the death of Mr. Chu, and they did not do so. And so I don't see how that could be harmless error. So the remedy that we're asking for today is that this is vacated from the sentence. And just to bring it back to further illustrate why the two are different, I think, again, the point that 910(3)B can be imposed in addition to other pecuniary damages is very different, and I think that only further indicates that this is a fine. Pecuniary damages can be calculated, and as you pointed out, they don't include pain and suffering. However, that does not mean that the victims or the estate could not potentially go into civil action in a wrongful death suit and have that sort of thing calculated for them. And I think that in order, though, to attach a sentencing enhancement, Mr. Davidson still has a right to a jury trial and has a right to be guilty until found beyond a reasonable doubt by a jury or a fact finder, that in fact his actions did cause the death of Mr. Chu. And because in this case that did not occur, we have no other choice but to vacate this portion of Mr. Davidson's sentence.
There's been a lot of talk about that dissent that Gorsuch wrote, where he talks about restitution and Apprendi. You know what, the one I'm referring to. I don't remember the case, but
Case, yes.
you're, I'm sure, more familiar with me. He says that the right applies to all restitution based on his analysis of the common law. Do you agree with that?
So I don't necessarily disagree with that. However, what I would say is that because my argument is very squarely that this is not restitution, that point wouldn't necessarily be important to make, I suppose, in this case. Again, I think it's very important that we look more so at the characteristics and the hallmarks behind 910(3)B, and I think it's very clear that this is punitive in nature and it's more like a fine. And so I would conclude with just saying that 910(3)B, because it is a fine, and based on the arguments I made today, we ask that the court vacate the $150,000 fine amount. Yes?
Same argument, or would it be as strong of an argument if your guy was the only guy, if there wasn't a second person involved in the shooting?
Same argument to be making. I think perhaps there would be some other questions, I would assume, by the justices in regards to maybe what would have the jury been thinking. But again, I think it's impossible in this case to determine, or in any case to determine what the jury had been thinking when they acquitted my client of several other higher charges that included elements that said his actions caused the death. And so I think I would be standing here and making the same argument that every single defendant deserves the right to be innocent until proven guilty beyond a reasonable doubt. Thank you.
Trout. You may begin after you tell us what high school you went to.
I graduated from Dowling High School, which is now known as Dowling Catholic, so that ages me, but
Whenever you're ready.
Ms. Laurens. Cesar Davison's actions were both the cause in fact and the legal cause of DeMarcus Chu's death. His acts established the causation.
Though, the jury.
The jury found the defendant guilty of assault causing serious injury. And all deaths are serious injuries. It meets the definition that the district court instructed the jury on. And our case,
The suggestion that there were 3 or 4 bullets that were non-life-threatening, and I mean, is there a way that my understanding of the difference between the charges was that the charges that were acquitted all required that they first find that he shot Mr. Chu, and then it caused a death at some different levels, or death resulted. But the assault did not require the element that he had shot, that he had shot Mr. Chu, but it did require that he had caused some kind of serious injury, is what they ultimately found. So what's your response to the idea that maybe they found that he shot at him, but didn't cause it because because of the acquittals?
according to the medical examiner's testimony, there were 4 of the 7 shots would have resulted in death. There is absolutely no testimony with regard to those other 3 shots that they caused anything. We don't know, essentially where they were or what organ or something that had impacted. But to meet the definition of a serious injury, so if the jury can't rely on what happened relative to those other 3 shots, the only evidence that the jury has pertains to the 4 shots that were fatal. So there's nothing that the jury could have relied on to establish that, well, these other 3 shots met the requirement for serious injury. That means that the jury must have found that those 4 shots are what they based their decision on. That's it. The only testimony was the only serious injury that occurred in this case was death, because there wasn't any other evidence supporting any other type of injury than death.
Reconcile that with the acquittal on the other charges.
Juries are different. We don't know what it was as far as their deliberations, which made them acquit on the murder, acquit on the second. But what we do have this is the assault causing the serious injury. And our case law states that death is the most serious injury. So when you look at the facts of this case, and there's no discussion of any other injury but death, that the serious injury that the jury found is the death, and that establishes the causation necessary to warrant the imposition of 910(3)(b).
I'm not following it. I'll just be brief, but why couldn't the jury decided, once again, yeah, there's 7 shots. There was testimony that 4 would have been fatal. That implies that 3 might not have been. A bullet wound is a serious injury. Why couldn't the jury have come up with that approach?
Again, there's nothing for the jury to rely on in that evidence that would.
That weren't fatal, and Davison might have been responsible for them, but not the 4 fatal shots.
But if a serious injury is defined as a bodily injury which creates a substantial risk of death, which causes serious permanent disfigurement or extended loss or impairment of the function of any bodily part or organ, there is a threshold that the jury must find to establish the serious injury. If there is no testimony with regard to what happened with those other shots, it necessarily finds that what we do have, the evidence that we do have, is that a death occurred. So if there's no testimony about those 3 other shots, and there's testimony about the 4 shots, plus we don't know the order in which they occurred, the fact that that 4 of those shots meet the requirement for the serious injury, that would be sufficient to establish beyond a reasonable doubt that he is responsible for DeMarcus Chu's death.
I should say, I mean, this is an interesting exchange. I appreciate it. And that suggests to me that maybe we should just look at the legal elements, and that is, was a death required? Death a required element of the charges for which he was convicted? And if the answer to that is no, then maybe he's got a point.
You can look at it that narrowly, because our case law tells us that the most serious of injuries is death. So if not all serious injuries are death, but all deaths are serious injuries, and if that's the only element, if that's the only evidence that's presented to this jury, then that's what the jury necessarily had to find. We can't rely on something that we think the jury may have done. What we have to look to is all the evidence.
And that's why it strikes me that a clean rule ought to be that you look at the elements for which there is a conviction, and if death isn't required.
Also, at 910(3)(b), the language says if the defendant is convicted of a felony which causes the death of another, this court has issued decision after decision where they have upheld the 910(3)(b) order where there isn't a finding of death. You look at State versus Rome, where it was supplying alcohol to a minor.
I thought that was a manslaughter or conviction, wasn't it? So I mean, there had to be a jury finding that the defendant caused the death of another, which isn't present here, is it?
Honor, I think that the serious injury, the finding of the serious injury, in this case, the serious injury is death, is satisfied.
Makes me a little nervous when, sitting up here when there's a really cogent constitutional argument made, and the first thing you do is argue with vim and vigor why we don't need to reach the constitutional argument. Let's say hypothetically we do need to reach that argument. Does Apprendi cover the $150,000 restitution? And why not?
For 2 reasons. To the extent that State versus Isolina provides that we're going to treat 910(3)(b) as a fine, I would state that Isolina went a little too far. Isolina was decided in
That
and
to agree with your position. I mean, does your position rest on us deciding that Isolina went too far?
it doesn't, because I believe that when you look at the The fact that the jury found a serious injury occurred and the death is the serious injury, even if Apprendi applies, I think that the restitution award should still be affirmed. But I don't believe that Apprendi applies because Apprendi was decided in 2000. Isolina was decided in 2000. Since Apprendi has, in the intervening 2 decades, the federal courts and state courts that have interpreted whether or not Apprendi applies to restitution have all found it does not. So if you, the reason I bring this up is because when the court decided Isolina, it didn't have the benefit of the wealth or all these other decisions from the federal courts as well as the state courts to say restitution does not apply to Apprendi. And the reason it doesn't apply to Apprendi is because it is civil in nature. And when I argued Isolina many years ago, my point was this is civil in nature. And the reason it's civil is because the award is not going to the state. It is going to the family or the estate or the heirs at law of the victim. So when you consider this, if you go back and would modify that Isolina, you didn't have the benefit of Isolina and what the other federal and state courts have found that Apprendi doesn't apply.
Seventh Amendment issue then on a right to a jury trial in civil cases?
Your Honor, what they have found, what the case law indicates is if this is an award between, like if it's to be treated as a punitive damage award between civil parties, that doesn't offend, I believe it was the 8th Amendment, but the 7th Amendment really hasn't entered into the discussion as far as what the cases that I found or any of the cases that were raised by the defendant. This was strictly a challenge to the imposition, or does Apprendi apply to 910(3)(b)?
At least our cases, I won't cover the Court of Appeals, that our prior cases, there's always been a jury finding, has always, that the defendant caused the death of the victim. That's always been part of the elements that have been found by the jury. That isn't, assuming that isn't the case here, assuming we disagree with your argument there, then this is going to be kind of an oddball case where you're going to have a right to a jury trial, because normally your right to the jury trial is fulfilled during the main criminal trial, correct?
Right. This court has stated in Maybury and Jenkins that there is no Sixth Amendment right to a jury trial in restitution. What I would submit would happen, perhaps, is that, first of all, I think that the jury did reach the causation, and I think that they did find the serious injury, that the death was the serious injury. Going forward, should it be by a special interrogatory? Perhaps. But in this particular case, I don't think that that was necessary.
910(3)(b) sub 3, when we're looking at the preclusive effects of the criminal judgment, that indicates that the offender is prohibited from denying the elements of the felony offense for which he was convicted. Doesn't that statute indicate, at least for Apprendi purposes, that we should be looking at the elements and not the underlying evidence? And maybe this is a subtle distinction, but for harmless error analysis, maybe we would look at the entire record. So what bearing does that statute have on this case?
You mean 910(3)(b) sub 3? Yeah. I think you have to reconcile, I think that you have to reconcile that with sub 1, which it just says a felony result that caused the death of another. And then we look back to the case law, which says that those restitutions aren't necessarily going to be limited to the parameters of the offense.
Subsequent civil case, for example, following this, the defendant would only be stopped from denying he caused a serious injury. You would still have to prove up the death in that civil case. So to me, that indicates that there wasn't a finding by this jury that the defendant's actions caused the death, maybe on this record, that's the logical inference, but at least on the elements, there was no finding, right?
Again, I disagree because the only evidence that was, I think that in a civil context that clearly
Other evidence, if you just told a civil jury, here's what this defendant was found guilty of, that would not prove death without additional evidence.
I think that you can't look at it in isolation without the finding of how a serious injury is defined.
He was convicted of murder. In the subsequent civil jury trial, you wouldn't need any additional evidence other than the verdict. A jury found this defendant guilty of causing the death of Mr. So-and-so, and that's all you need. The case is done, it's over, then you're at damages. If you were to try this case, you would have to have a whole trial on causation and death.
I don't think so, Your Honor, because, the murder situation clearly is, it's a slam dunk, of course. But in this particular context, if that civil jury is also going to be told how we define a serious injury. And I think that when you look at what happened, that DeMarcus Chew is dead, and that when we've met that threshold for the serious injury, and that he's dead, I think that the jury would put two and two together, and that Mr. Davison is responsible or caused the death. So I think that that's sufficient, and that's what I have kept talking to the court about or discussing, that the serious injury is sufficient, or the finding of serious injury is sufficient to find that he caused the death.
Hypothetically, his shots were not the fatal ones. He's acting in concert, and the victim is dead as a result of the shooting. Does that acting in concert get us to where we need to? Does that prove the causation?
I would like to say yes, but the fact of what the other co-defendants were convicted of is not in the record. The other actions, I think that we have enough just looking at the elements of this offense with the serious injury. Clearly, this was I'm a little surprised that the jury returned a verdict of assault causing serious injury. I thought that the evidence was compelling, if not overwhelming, but that's what the jury found. And so clearly he was acting in concert with the other co-defendants. If there are no further questions, yeah.
Surprised by what the jury found, and I guess to some extent, isn't that the point of Apprendi, which is sometimes juries do things, and although maybe we think the evidence would indicate something else, that's why we submit these questions to the jury, because they exercise their judgment, community conscience, common sense, and here they didn't find he was guilty of murder. Why should we treat the restitution award differently?
I think that your version of reading it, like what happened, and my version are going to be different, because I think that the requirement for Apprendi is that we just didn't want a more severe sentence without that jury finding. In this instance, it seems to be a compromise verdict. But being a compromise verdict still doesn't negate the fact that DeMarcus Chew is dead, and that this defendant's actions caused his death. Even though he was convicted only of committing a serious injury, that serious injury, and the only evidence to support that serious injury, is death.
If I may, the record shows that there was an autopsy, and he was shot 7 times, as you said, and 4 of them were said to be fatal. 1 to the head, 3 times to chest and abdomen. The non-fatal shots appear to be 1 in the pelvis, 1 in the left arm, and 1 in the left leg. Those strike me as serious injuries. A shot to the pelvis is a serious injury. It was not a death-causing event. A shot in the arm strikes me as a serious injury, not a death-causing event, and 1's in the left leg. So, I mean, the jury could have decided, well, there's just not enough evidence that this guy fired the fatal shot. There's evidence that he fired among the shots, and we'll get him for serious injury based on the pelvis, leg, and arm. Couldn't a rational jury do that?
No, because the evidence doesn't support that, Your Honor. The only evidence, had there been testimony that the shot to the arm grazed, or had there been something else, even that testimony doesn't rise to the level that it would establish the threshold necessary to prove the serious injury. And for that reason, if we had some testimony that, he was shot in the pelvis, it severed a spinal column, something more, then that might be. But you're just relying on speculation, what the jury could have found. And
Of law, we should hold that a shot to the pelvis, somebody can't infer that's a serious injury without expert testimony.
it depends on where the pelvis. I mean, there is a lot that we don't know relative to what this medical testimony was. Was it, did it clip the pelvis? Did it sever something? We don't know because DeMarcus Chew was dead, and what we have established is that 4 of the 7 were kill shots, and that, or would have resulted in his death. The fact that the only evidence in the record supports serious injury was death. And that's what we rely on. That's what we believe the jury found, establishing the causation necessary to impose the $150,000. Thank you.
Thank you. Ms. Laursen?
Thank you. So I just wanted to read quickly from the appellee's brief here. It says the medical examiner testified the gunshot wound to the head was rapidly fatal, although the wounds to Chew's lungs and liver would also have been fatal. So essentially meaning that there were, like we've been talking about for the last several minutes, several shots that were not fatal and would constitute a serious injury, for example, to the pelvis.
Think of the fact that the jury also acquitted him of the lower assault. So they could have found assault causing bodily injury or just plain assault, but they chose serious injury, which was specifically defined, as your opposing counsel read, within the jury instructions. And so what's your response to that?
Yeah, so I think that a gunshot wound would constitute a serious injury. And so I don't know what other bodily injuries perhaps could have resulted in this fact pattern, but I do think it's a very good point that, maybe Ms. Trout and I would agree on, is that we don't know exactly why the jury acquitted Mr. Davison of the several murder charges that he was charged with. What we do know is that the jury acquitted him of them. He was...
Instruction 25 talks about the wound or wounds inflicted upon the victim resulted in the death of the victim if said wound or wounds caused or indirectly contributed. Even if let's say that your client shot the victim in the legs and he couldn't run. Shots, wouldn't that be a contribution to his death?
It perhaps could be found that that is a contribution to someone's death, but I think now we're getting into more of, what does the word cause mean in the statute? And because 910(3)B, as I've been arguing, is a fine, and as this court has found in Corwin, it's a sentencing enhancement, the word cause can't just be, a tort version of that word. It has to be beyond a reasonable doubt. It's not something that we can find, in a civil standard preponderance of the evidence. It's beyond a reasonable doubt. The jury or the fact finder has to find that the defendant's actions were the cause of the victim's death. And in this case, that just did not happen. In the future, perhaps there could be a special interrogatory, something like that. However, I think that in some way has to be a finding made beyond a reasonable doubt by the jury, by the judge, whoever the fact finder is, in order to enhance the sentence by applying or imposing 910(3)B. And I don't know how you could...
harmonize our cases? There are plenty of cases that say Apprendi does not apply to regular restitution awards. And this statute that awards an automatic $150,000 if there's a death caused by the felony has a dual purpose, and one of the purposes is civil. Aren't we done? Even if the other purpose is criminal, and for that you got the excessive fine Eighth Amendment cap on it, and it passed muster under Isolina. But why can't the civil hybrid purpose of this escape an Apprendi requirement?
Apprendi is doing, and the whole line of cases that follow it are, making sure that the criminal defendant's rights are upheld, their constitutional rights are upheld by the government. And so to say that just because perhaps there are some, it's a hybrid and there's some civil portions of this, I don't think that that's the end of the analysis. It's the fact that there's even, 1% of this is criminal. That means that, your constitutional rights to, the deprivation of life, liberty, and happiness, that should all apply. I don't think just because perhaps we can say, there's some civil aspects to this, and so therefore we just shouldn't care about someone's life, liberty, and happiness rights.
This out. So let's say we agreed with you that under Apprendi there's a right to a jury verdict that your client caused the death of another before imposing the 910(3)B restitution. So say we agree with that. Then the remedy, I take it, would be to vacate the restitution, and then there would be a right to a jury trial on that restitution, right?
I think the remedy here would be, yes, to vacate. And then I don't know that you could go back and have another jury trial. The jurors.
Is there now a double jeopardy problem because that issue was in fact already submitted to a jury and a jury rejected that because the jury had the opportunity to convict your client of offenses that involving cause the death of another and declined to do that?
I agree with you. I don't think that we could just, get a new jury in here and decide, and, based on these facts, should we apply this additional sentencing enhancement? I think that you have to vacate the sentence here. And if the court wants to, further instruct in the future, this is what, lower courts may need to do in order to, apply 910(3)B, I think that would be helpful. But in this case, we must vacate the sentence, and there's no additional opportunity without violating the double jeopardy clause here, because the jury already had every opportunity to convict him of those charges, and they acquitted him. Okay, so to conclude, we're asking today that the 910(3)B be vacated from the defendant's sentence. Thank you.
Versus Davison is hereby submitted, and the court will adjourn for the morning. Thank you for joining us today, students.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.